Yes.
So I'm going to continue with documents relating to the HIV litigation in Scotland, and I'm going to pick matters up shortly after the correspondence that we looked at before the break, a minute dated the 8th of February 1991 from Mr. Tucker to the Private Secretary to the Secretary of State. The reference is SCGV 40232_110. Now we can see in paragraph 1 of this document, Mr. Tucker made reference to the correspondence we looked at a little bit earlier. In paragraph 2, I just want to pick up a few points in the first part of this paragraph. Mr. Tucker wrote, "The Secretary of State for Health seeks assurance, however, that the terms of settlement in relation to the size and categories of payment must be common to all litigants, and we can readily give this assurance." So making the point that the size and category of payment for litigants in Scotland should be the same as that in England and Wales. On the matter of informal soundings, Solicitor's Office has already shown a draft settlement adjusted to reflect the Scottish legal situation to the solicitors representing the main group of Scottish litigants. But the main difficulty to a speedy conclusion of the consideration of the offer, and consequently the reason for a more protracted timescale in Scotland, lies in the investigative work which Scottish solicitors require to undertake if they are to be in a position to give advice to their clients on the merits of settlement. In the vast majority of cases, Scottish solicitors are unable to undertake that work until legal aid has been granted, and then some more detail on how that problem might be overcome, concluding with a recommendation at the bottom of this paragraph that an additional 3 months be offered to litigants in Scotland. So we can see there officials agreeing that effectively the settlement, at least in terms of size and categories of payment, should be the same in Scotland as in England and Wales, referring to some of the reasons that I outlined earlier for why more time might be needed in Scotland, and also referring to draft settlement terms having been shown by Scottish Office solicitors and lawyers involved to those representing litigants in Scotland. So that's February 1991. Over the months that follow, and I'm going to start by going up to May 1991, there are a series of letters and meetings going back and forth between officials in the Scottish Office and officials in the Department of Health, and also lawyers representing Scottish litigants on the terms of settlement in Scotland, negotiations over their terms, and liaising between the two departments about what the settlement terms should look like and how they should be framed exactly in their detail. In the addendum notes that the inquiry is going to provide to court participants as quickly as we can, we are going to attempt to trace the back and forth of some of that correspondence over their months, with an eye in particular to developments which relate to the question of a waiver for those who agreed to the settlement terms. This waiver issue related to an undertaking that litigants were asked to give in order to get the benefit of the settlement. The undertaking was to effectively give up the right to bring a further claim against the different defendants or defenders to these actions arising from infection with blood products, factor 8 and factor 9. Now, the particular issue that we're concerned with was whether that undertaking was intended to and did waive litigants' rights to future claims concerning only infection with HIV or also infection with hepatitis. Now, the detail of the correspondence and the drafts of terms and drafts of declarations of trust for the Macfarlane Trust Number 2 that's eventually declared is going to come in the note. For the purposes of today, I can pick up the chronology on the 3rd of May 1991 with the declaration of trust for the McFarlane Special Payments Number 2 Trust. That is at MACF 5083_004. So we have the date at the top, 3rd of May 1991, Declaration of Trust constituting the McFarlane Special Payments Number 2 Trust. Now, this is a document which reflects compromise reached in England and Wales for the HIV litigation. At the time that this trust deed was executed, negotiations over the Scottish settlement were still ongoing, and some of the contents of this document reflect that. Before I go to the parts of it that relate to Scotland, I just want to pick up on page 22, please. Thank you. Now, this is the undertaking which was to be given by litigants in England and Wales. We don't need to go through all of the technical detail. What we can see is that what this undertaking required was to undertake that I will not at any time hereafter bring any proceedings against the Department of Health, the Welsh Office, various other defendants, or any other government body, and this is towards the bottom of this passage, involving any allegations concerning the spread of the human immunodeficiency virus or hepatitis viruses through Factor 8 or Factor 9, whether cryoprecipitate or concentrate administered before 13th December 1990. So an undertaking that appears to cover both future claims relating to HIV and hepatitis viruses. If we go, please, first to page 24. We don't need to go to the detail of these pages, but this is a Schedule 3 which modifies some of the provisions of the trust deed so that they can apply to the settlements in Scotland, cover a number of particular issues. If we could go to page 27, Schedule 4, an undertaking to be given...
Just go back for a moment.
Of course.
Schedule 3, please.
Of course. Back to page 24, please.
Thank you. Thank you.
And if we go back to page 27, please, Lawrence, Schedule 4. Here we have the undertaking to be given by a qualifying person in Scotland to receive payment from this trust. The second half of the page, please. I won't go through all the detail, but I'm going to pick out a few references. Paragraph 1, I hereby discharge the said Secretary of State, which is the Secretary of State for Scotland, all other ministers, different defenders, from any liability they may have in respect of the infection of X person with human immunodeficiency virus or hepatitis virus allegedly arising out of treatment before 13th of December 1990 with Factor 8 or Factor 9. This document continues over the page with references made at various points to both HIV and hepatitis. For example, we can see that in paragraph 4, I undertake not to bring any proceedings against the Crown or any health service body now or at any time in the future in respect of infection by HIV or hepatitis viruses. So what we appear to have here is it being envisaged that in Scotland, as in England and Wales, there'll be an undertaking to waive the right to bring future claims, and that that waiver will cover both hepatitis and HIV. So,
just one question about it.
yes.
The waiver, so far as it related to England and Northern Ireland, etc., it was a waiver which in terms, as I read it on the screen, related to the proceedings were not related to the spread of, or the spreading of, HIV or hepatitis viruses. This is rather different because it doesn't mention the word spread or spreading. It does mention the infection of somebody, which I think the first waiver doesn't. Am I right in that distinction?
So you're right that on their face, those two different versions of this waiver.
Yes, so you say this waiver, they're two different waivers. They may come to the same effect, but the one is in respect of the spreading of, any allegation about the spread of, which is peculiarly vague, or might be thought to be, and this one, which is much more specific to the individual, which is the infection, presumably of the individual, that's the blank, by the HIV or hepatitis. Does anything turn upon that distinction, or do you want time to consider that?
Well, it's time to consider it. So that sounds to me like one of the issues which should and could sensibly be addressed in the addendum note that we're intending to disclose. Looking at those differences in the wording of these waivers, the extent to which their legal effect changed as a result of that different wording, spread versus infection, as a part of trying to disentangle the nature of the infections that they covered.
And can you help at all this waiver? Could we just go back to the start of this waiver? Thank you. A qualifying person it relates to. The undertaking, so far as the English and Northern Irish and Welsh claimants were concerned, it excluded those under disability. In other words, it excluded children from the waiver. So it wasn't a question of the waiver being a contract, a minor's contract, which was given validity by the judge's approval. That issue never arose, presumably, but I don't know. You can tell me, or you may want time to think about that as well.
I think there'll be another one to address in the notes.
In due course.
In due course, it's certainly the case that we can see in the documents referred to in the current presentation note that we have, that the Scottish lawyers who were involved in trying to reach agreement on settlement terms in Scotland were alive to differences between England and Wales and Scotland on issues like minors,
Yes.
under 18s, and how these settlements might apply to them.
Well, I would expect that to be the case, but I'm just curious about the position of those in England and Wales, as it happens, who were under a disability, that is, not legally capable of giving consent to a waiver, not legally capable of making a contract, at least in the minor's case, without an approval if the contract was thought to be for their benefit. But I'm summarising the provisions of the Act, but that I think would be the position in England and Wales, and presumably Northern Ireland as well.
So we'll seek to bottom out some of those differences that I've described and that you've alighted on. For today's purposes, we can turn next to the formal offer that was made by the Scottish Office to solicitors representing litigants in Scotland to settle the litigation, which took place about nearly 2 months, 6-7 weeks after this document, the 24th of June 1991. Could we please go first to DHSC 303635 _ 065. So a document dated the 24th of June 1991, addressed to Balfour and Manson. It comes from Richard Henderson from the Scottish Solicitor's Office. If we look at the second paragraph, Mr. Henderson wrote, "I'm authorised on behalf of the Secretary of State to offer formally to you terms of settlement for individual claims at the instance of pursuers listed in Annex A to this letter, and for the settlement of claims for damages against the Secretary of State on behalf of those claimants listed in Annex B. The terms of settlement are set out in the document labelled Annex C, attached with this letter. I also attach a copy of the Macfarlane Special Payments No. 2 Trust dated 3rd of May 1991, the document we just looked at, together with a copy of revised draft Schedule 4 to the Deed of Trust. Arrangements are being made to vary the terms of the Deed of Trust to facilitate payment in terms, I think that should say in the terms of settlement. This will entail substitution of Schedule 4 and also Schedule 3 form of undertaking. The appropriate form of undertaking is set out in Schedule 1 to the terms of settlement. I understand that you will arrange for the offers to be communicated to the individual pursuers and claimants through their appropriate legal advisors." And just over the page, just the first paragraph there, Mr. Henderson writes that upon receipt of that pro forma letter and schedule, we will issue the appropriate certificate to the Macfarlane Trust, so outlining the procedure for claims to be settled. We understand that thereafter the Trust should be in a position to release payments to individual claimants. Now, the detailed terms of settlement with the proposed substituted undertakings that accompanied this letter, we understand to be the document at BNOR 40329. Now we can see in the top right-hand corner Annex C, which was the same annex letter referred to in that cover letter we just looked at. The title of this document, Detailed Terms of Settlement of HIV Haemophilia Claims in Scotland. Now we don't need to go through all of the terms that are offered in this document. If we could please go through to page 11. We have an undertaking, which, as we'll see, is different to the undertaking contained in the 3rd of May 1991 Declaration of Trust. The title, the top, undertaking to be given by a qualifying person to receive payment from the Macfarlane Trust. And if we go down to the bottom half of the page, I hereby discharge said Secretary of State for Scotland, and all other ministers of the Crown, government departments and other bodies, for any liability they may have in respect of the infection of X person with human immunodeficiency virus. No reference to hepatitis viruses allegedly arising out of treatment with Factor 8 or Factor 9, whether cryoprecipitate or concentrate. The remainder of the undertaking sets out other forms of wording, discharging parties from agreeing to give up the right to bring future claims, again, seems relating only to HIV and not hepatitis viruses. So we seem to see in this document a different undertaking and a waiver that's different in its scope, addressing only HIV and not also hepatitis. I can then move on, please, to the variation to the deed of trust which took place in September 1991. A minute ago, when we looked at the cover letter that was sent to Scottish litigants' representatives, it's pointed to the fact that, or suggested that it was going to be necessary to vary the deed of the McFarlane Trust. And we can see that document at MACF 5083 _ 003. So 19th of September 1991, deed of variation relating to the McFarlane Special Payments No. 2 Trust. And over the page, following an introductory wording, at the bottom of this page, now this deed witnesses as follows: substitution of Schedule 3. For Schedule 3 to the trustee, there shall be substituted the following. And if we go over the page, a different Schedule 3 is proposed. For current purposes, going to focus on page 7, where there is substitution for Schedule 4. And this Schedule 4 appears to be in the same terms as that which we just considered. In other words, only containing a waiver for HIV and not also containing a waiver for hepatitis. Now, what that suggests is that the waiver which applied in Scotland rather than England and Wales applied only to future claims relating to HIV and not also to hepatitis. We are going to come back in the note that we're going to disclose to try and trace in a bit more detail how it was that that came about, if indeed that's right, as well as addressing the points that you raised in our discussion earlier. Now, one of the issues that arose following the settlement of the main HIV litigation claims in Scotland related to a category of claims which was termed Category G. The written note sets out some detail on this issue. It arose around September 1991, concerned Category G claims. Broadly put, these were claims for compensation by spouses, parents, and children of HIV-infected haemophiliacs who had not themselves been infected with HIV, but were at risk of doing so because of their close and regular contact with an infected haemophiliac. Now, those claims were restricted by certain criteria because of differences in the way the litigation in England and Wales proceeded and that in Scotland, and because of ways related to the settlement was being reached. The restriction on eligibility for Category G claimants had the effect of excluding more claims in Scotland than England and Wales. This issue arose. It was considered by officials in the Scottish office. There were discussions between those officials and representatives of the Department of Health. What appears to have happened is that the eligibility criteria in Scotland were changed. As a result, more claims became eligible, and this was at least an attempt to mitigate or reduce the disparity that seemed to have arisen for this category of claims between Scotland and England and Wales. There's some detail contained in the written note, and I'm not going to address it any further today, sir. Now that concludes what I intended to cover today about the HIV litigation. I'm going to finally address quite briefly compensation claims and decisions related to HIV infection through blood transfusion. Now we go back in time, we can see in the documents that around the time of the additional payment to the Macfarlane Trust in November 1989, consideration was given within the HHD to the question of compensation or other payments for patients who had been infected with HIV through blood transfusions rather than treatment with factor concentrates. In early 1990, Lord Forsyth, who was the relevant minister at the time, was advised that the UK government position was that compensation would not be paid to such individuals. So no doubt you'll recall Lord Forsyth gave oral evidence on this issue. He described, if I can paraphrase it, being unconvinced by some of the reasons that were put to him by officials for this position. Nonetheless, the overall policy position of the Home and Health Department remained in line with that of the wider UK government. And the position was that no money would be paid to such patients. This issue arose again a little while later in early 1991 in the context of the HIV litigation. The document suggests that around this time when the issue came up again, Lord Forsyth effectively reaffirmed a view he'd expressed previously that the distinctions that were being sought to be made between haemophilia patients and transfusion patients didn't stack up. We can see a number of documents that are summarised in the written notes in which this particular issue was discussed by departmental officials, discussed with lawyers in the Scottish office, and some of those discussions were prompted by correspondence which had been sent by campaigning groups to the Department of Health and responded to by Department of Health ministers. The HHD became involved. There was some criticism we can see in the documents summarised in the notes of the distinction which was being maintained between haemophilia patients and transfusion patients. Nonetheless, the position continued to be that of the wider government, which was no payments would be made. We can get an insight into Lord Forsyth's views from a contemporaneous document. That's SCGV 40234_198. Now, it's dated 2nd of May 1991. I haven't gone to the minute which preceded this document, but it was one which reaffirmed the government position that no money was to be paid to individuals who'd been infected with HIV through blood transfusion. And it records this. It's from Mr. Forsyth's private secretary. Mr. Forsyth has seen Mr. Tucker's minute of 29th of April 1991 and your minute of 1st of May 1991 about whole blood transfusions. Mr. Forsyth considers that this is an extremely serious matter and that the government's position is indefensible. He has commented that we're in danger of losing a lot of goodwill carping over a small financial obligation. Our refusal to release information on records leaves us particularly vulnerable. Mr. Forsyth hopes we might try to change the government's line on this matter. And now, despite the view that was expressed there on behalf of Lord Forsyth, the government position adopted by the Scottish Office was maintained for most of the rest of 1991. The position changed in December 1991 when the Secretary of State for Health in England and Wales recommended a change of policy to the Treasury that was accepted. Now, similarly to other examples we've considered today, that change of policy appears to have happened with little or no consultation between the UK government, the Secretary of State for Health, and ministers and officials in Scotland. Despite that lack of consultation, there was again a request for Scotland and the other departments in the UK to contribute some of the funding that would be required for this change of policy, and there are a number of documents in which officials and subsequently ministers address this question of whether and how much they should be expected to contribute to the payments to these individuals despite the lack of consultation from central government. These issues were set out in a submission from Mr. Tucker to ministers in December 1991, which proposed that the Scottish Office should accept the changed policy and also that a financial contribution should come from the Scottish Office to these payments. That was accepted by ministers. Now, there was then, over the next few months, work to finalise and set up the scheme through which payments would be made to individuals who've been infected with HIV by blood transfusion or tissue transfer. And in the last document I'm going to bring up today, I'm going to highlight how the document describes the scheme which was agreed and set up, but also link back to the waiver issue we were discussing earlier. It's dated April 1992, and it's at SCGV 40239_024. Now, this is a minute dated the 9th of April 1992. It's from Mr. Tucker to the Chief Executive of the NHS in Scotland, I believe was Mr. Cruikshank at the time, seeking his approval for the Scottish scheme for payments to HIV-infected recipients of blood and tissue. We can see that from the first paragraph. The remainder of this document sets out the detail of the scheme, the background to it, and I'm not going to go into that detail now. I'm just going to pick up on page 2 the section headed Differences with English Scheme, and then paragraph 9. I should also draw to your attention the terms of Annex 1 to the scheme, which sets out the form of undertaking to be given by the applicant. Our form does not require an undertaking discharging the Secretary of State in respect of liability for infection of the applicant with hepatitis virus. In that respect, it differs from the English form of undertaking. However, again, we consider ourselves to be bound by the terms of the haemophilia settlement, which did not limit an applicant's rights in connection with hepatitis infection. We've had strong representations against extending the undertaking into this area. Our medical and legal advisors specifically support the exclusion of reference to hepatitis from the undertaking. So again, a difference in the nature of the waiver undertaking applicable in Scotland as with England and Wales, to be explored further in the note, which will be prepared by the inquiry team and disclosed as soon as we can. So that completes the material I intended to cover today. We've covered a large number of topics, a large number of documents. I hope it's been of assistance in setting the framework and the structure for the detail which is contained in the written note, which has already been disclosed.
Yes, well, thank you very much indeed. Tomorrow?
So tomorrow we return with a witness. We'll be attending remotely John Canavan, an official from the Department of Health.
So John Canavan tomorrow at 10 o'clock. 10 o'clock. Thank you very much.